You, Professor Tillipman, you are now recognized for your testimony. Thank you.
Chairwoman Maloney, Ranking Member Comer, and the members of the committee, thank you for inviting me to testify in this legislative hearing. I am Jessica Tillipman, the Assistant Dean for Government Procurement Law Studies at the George Washington University Law School. In addition to leading the law school's government procurement law program, I teach our anti-corruption and compliance course. The interim majority staff report provides a compelling case study in how conflicts and compliance issues significantly undermine the public's confidence in our procurement system and the contractors that provide the U.S. government with critical goods and services. The U.S. government procurement system aspires to obtain the best goods and services from the best firms at the best prices. To attain these goals and ensure taxpayer dollars are appropriately safeguarded, the Federal Acquisition Regulation, or FAR, makes clear that the government procurement process demands the highest commitment to ethical and unbiased conduct. To maintain integrity in the system, entities that do business with the government are subject to a patchwork of requirements, restrictions, and compliance obligations. The House report presents two important questions. First, whether the FAR's current Organizational Conflict of Interest, or OCI framework, adequately addresses potential conflicts between a contractor's public sector and private sector work, and, if not, what legislative changes could help avoid potential conflicts of this nature in the future. With respect to the first question, any objective observer with a basic understanding of the FAR and access to Google would conclude that existing OCI regulations most certainly cover conflicts between a contractor's public and private sector work. As to the second question, the OCI language in the FAR, which has remained largely unchanged since 1984, should be revisited. It is no longer reflective of modern procurement practices and the sophisticated body of OCI case law that has developed over the past several decades. OCIs are generally separated into three categories, but most relevant today is what's referred to as an impaired objectivity OCI, which may arise where a contractor's outside business relationships create an economic incentive to provide biased advice under a government contract. Experience suggests that OCIs are more likely to occur in contracts involving certain services, such as management support services and consultant or other professional services. The FAR requires a contracting officer to avoid, neutralize, or mitigate significant potential conflicts before contract award. To fulfill this obligation, contracting officers depend on contractors to disclose actual or even apparent OCIs. The failure to disclose information required by an applicable OCI clause can lead to a multitude of adverse consequences, including contract termination, prosecution for false statements, False Claims Act liability, or even suspension and debarment. Given the potentially severe consequences for failure to disclose an actual or potential OCI, most experienced contractors take affirmative steps to identify potential conflicts of interest and, to the best of their ability, mitigate them by, for example, developing firewalls, executing non-disclosure agreements, or shifting work to a neutral, unaffiliated third party. All of the issues highlighted in the House report must be considered against the backdrop of a growing global consensus on the importance of internal ethics and compliance programs designed to prevent, detect, and mitigate ethics and corruption risks. Given the heightened corruption risks and compliance obligations associated with government contracts, most sophisticated government contractors have invested heavily in risk-tailored ethics and compliance programs to reduce the risks they face. Moreover, given the increased OCI risks associated with contracts involving management support and consulting services, contractors providing services of this nature would be expected to dedicate a greater proportion of their compliance resources to this particular aspect of their compliance program. Notably, merely adopting an OCI policy is not enough. An official policy that appears strong and protective is virtually meaningless if ignored. To be clear, an occasional violation or deviation does not mean that compliance program is ineffective. However, evidence of a systemic disregard for compliance policies and procedures, particularly when committed by senior leaders, is often very strong evidence of a weak culture of compliance. In 2011, the FAR Council thoughtfully proposed a revision of the FAR's OCI rules that addressed numerous outstanding issues. Although the rule was ultimately withdrawn, the House report reminds us that it's time to revisit the work the FAR Council began over a decade ago and bring greater awareness and compliance attention to this important issue. Thank you for the opportunity to discuss this important matter with you. I would be pleased to answer any questions.